There have been controversies everywhere these bodies have been tried, and the big question is whether the new body will only expose real corruption and not do damage through public show trials. Here's the Prime Minister in Question Time.
We do need to restore faith in our political system. We need to make sure that there's transparency, that there's accountability and that there is integrity.
Let's bring in Mari Shaw. KC, they all used to be QC, now they're KC. She's President of the South Australian Bar Association. Thanks for joining us, Mari. Good to talk to you. Look, these anti-corruption bodies have got a checkered history in all the states. It's a complex area of delivering justice. But the key contest to me seems to be whether the processes are conducted publicly, and we've seen a lot of that in New South Wales, or whether they've done privately, which has been the approach most common in your home state of South Australia. What are the advantages and disadvantages of those two approaches?
Well, Chris, I think in both approaches, the key question is how much of the legislation is going to take away ordinary Australians' rights that they would have if, for example, they were going through the trial process. So the bill in South Australia essentially required people to answer questions. They could not, for example, refuse to answer because it happened to concern their father or their child. They couldn't refuse to answer on the grounds it might incriminate them. They could assert that ground, but they could not maintain it. And here, at least with the private hearings, their reputations and integrity were not forever damaged, despite there being a complete finding of no corruption or no maladministration. However, we did have the experience here that of one of our most senior police officers, Chief Superintendent Barr, who was the subject of an AUCAC inquiry for some 2 years, and his widow gave evidence before a parliamentary committee after he took his own life, and he took his own life 8 days after a report which had not been released to him cleared him of all misconduct and maladministration. And so his wife or his widow gave evidence explaining how the nature of the ICAC investigation process caused him to be a broken man in effect. So what the ICAC processes here involved was compelling, for example, as I said, the wife or the husband of a person who happened to have the misfortune, one might say, of working for government, whether it was as a cleaner or whether it was as a politician or whatever it might have been, to face the prospect that any witness, any person could be summoned to a secret hearing. They couldn't tell anyone where they were going. For example, if you had to pick up your kids and you're a mum, you couldn't tell your husband that you'd just been summoned to a secret hearing.
See, this is extraordinary.
You couldn't tell anyone except a lawyer.
This is why these bodies are inherently problematic.
And so,
why can't we just allow the law, because corruption is illegal, the law to be applied normally? Because whatever you do with these bodies, if you say, as you're explaining there, when there are secrecy provisions, people can be denied natural justice because it is so secret. On the other hand, if it happens publicly, then people are denied natural justice because the allegations are out there everywhere before anybody's found anything.
Well, the problem with the public hearing is that you are condemning somebody without the benefit of the fair trial rights, which include a presumption of innocence, and also include an investigation by your police department, which starts from a premise that we need to find evidence both for and against the person we're looking at. And the police, when they investigate it objectively, arrive at a position that, do we have reasonable cause to suspect someone of an offence? And then you are subject to the independent judiciary evaluating those allegations. If your body, and I can only go on the experience here, if your body has essentially a marching instruction that you are to weed out corruption, then the issue is, how do you wrap around that the protections that your corruption investigation starts with gossip, starts with hearsay, that all becomes public. You're obliged to answer questions publicly. You are humiliated publicly. And whatever the outcome, whether in fact the the person who's being investigated can actually bring forward 100% proof that the whistleblower, and I'm all for whistleblowers, actually had his own agenda or her own agenda, and it's shown to be complete rubbish, your life is over and you can never recover. And from my point of view, growing up in country South Australia, I'm well aware of the history of my forefathers, and in one family 4 sons went to war and not one came home because they thought they were preserving what we value most in this country, and that is the right to a fair trial. A fair trial by an independent judiciary that takes into account that the power of the state is pitted against an ordinary Australian. And that can be, as I said, it can be someone with mental health issues who might be summoned to answer questions. It could be someone who has no means, would not think to speak to a lawyer. And when the lawyers were able to go with a person who was summoned, they could not stop the questioning. The person who was being interrogated.
It's such a worrisome area and complex as well. Thanks so much for joining us, Murray. I appreciate it.
Not at all. My pleasure, Chris. Thank you.
Murray Shaw there, King's Counsel from South Australia, one of the leading barristers in this area. Now, the point here is that all the states have had these bodies and none of them have got it right. And now we reckon Canberra, well, it's going to get it just right. Very ambitious, I would have thought. We've got to keep a close eye on it.